Welcome to the second session of Module 2 of the training course on export development under Vietnam new free trade agreements. My name is Loan Lê, and I'm looking forward to taking you through this module.
This session will introduce the general rules pertaining to customs and trade facilitation, SPS, TBT, and IPR under the CPTPP and what these mean to cooperatives. We will first discuss customs administration and trade facilitation commitments under the CPTPP. As a reminder, trade facilitation measures refer to the simplification, modernization, and harmonization of export and import processes, meaning anything that could help to reduce the administrative burden and fasten the import and export procedures. In this session, we will introduce some of the key trade facilitation measures that parties, or the governments, have committed to implement under the CPTPP. The first group refers to measures that aim to enhance the predictability and transparency of import and export procedures. The first measure is advance rulings. Under this measure, governments commit to providing binding written rulings on the tariff classification, or HS code, origin, or customs valuation of a good prior to the importation of a good when requested by the importer, exporter or producer. This measure will be extremely helpful for cooperatives to correctly identify how their goods will be treated in terms of classification, rules of origin and/or customs value. Additionally, cooperatives can also request for advice or information, and the customs authority is required to expeditiously provide advice or information as requested on quotas, duty drawback, deferral, refund, or waive customs duties, eligibility requirements for goods re-entered after repair and alteration, and country of origin marking. To further ensure transparency of rules, the governments are also required to publish, including on online medium, its customs laws, regulations, and general administrative procedures and guidelines, as well as to maintain inquiry points to address inquiries from interested persons concerning customs matters. The second group of trade facilitation measures pertains to measures enhancing accountability. These include measures on the review and appeal procedure and measures to ensure the confidentiality of submitted information. Under the rule on review and appeal, the government must ensure that any person who receives a determination on a customs matter has access to an independent administrative review and a judicial review of the determination so that they can seek further judgment or ruling on their matters. Under the confidentiality rule, the customs authority shall adopt or maintain procedures for protecting confidential information submitted to them from unauthorized disclosure. This includes information for disclosure could harm the competitive position of the person providing the information, such as information on pricing or business partners. The third group covers trade facilitation measures to accelerate the import and export processes at the border. These include rules on automation, express shipment, and release of goods. On automation, the governments commit to making electronic systems accessible to importers and exporters. Through such an electronic system, traders can submit customs clearance documents online, which will save them time and resources spent going to the customs offices to submit the documents. The CPTPP also encouraged the customs authorities to provide a facility to allow for the completion of import and export requirements at a single entry point. In Vietnam, have long been able to submit all documents through the national single window. The second rule is about release of goods. The CPTPP requires parties to simplify customs procedures for the efficient release of goods. These include: release goods within 48 hours of the arrival of the goods, where possible, provide for the electronic submission and processing of customs information in advance of the arrival of the goods, and allow the release of goods prior to the final determination of customs duties, taxes, and fees by the Customs Administration, subject to eligibility for release of the goods and payment of security or payment of duties, taxes, and fees under protest. The third rule under this group is about express shipments. Under this rule, the customs authorities are required to adopt or maintain expedited customs procedures for express shipments. These procedures include allowing for pre-arrival submission and processing of documents for the experiment. The single submission of information covering all goods contained in an express shipment through electronic means if possible, the release of certain goods with a minimum of documentation where relevant, and the release of express shipments within 6 hours after submission of the necessary customs documents under normal circumstances. Together, These rules will help traders reduce the time it takes to clear imported or exported goods at the borders, reducing the administrative and operational costs linked to these activities. The last group pertain to administrative measures, which encourage compliance of traders to avoid any legal consequences such as administrative penalties. Under the CPTPP, governments commit to adopt or maintain measures that allow for the imposition of a penalty by customs authority on traders who have committed a breach of the country's customs laws, regulations, or procedural requirements. The violations can be related to tariff classification, customs valuation, country of origin, and claims for preferential treatment under the CPTPP. In other words, if traders made falsified statements and documentation to benefit from lower tariffs CPTPP, they are subject to penalties, depending on the severity of the violation. The Customs Authority will also adopt a risk management system for assessing and targeting inspection activities on high-risk goods, therefore simplifying the clearance and movement of low-risk goods. Typically, the Customs Authority will use a tiered, color-coded risk classification system. Risks are classified under the green, yellow, and red lines. The green line means no control, under which the trader is exempt from checking documents and inspecting goods. The yellow line means documentary control, under which the trader must submit additional documents for customs to check. The red line means physical control, under which the trader must submit documents as in the case of the yellow line, and the customs will conduct a physical inspection of the goods. The customs will base on several information to determine level of risk, such as the trading history of importer/exporter, country of origin, and the sensitivity of goods. When exporting, cooperatives, therefore, have the incentive to comply with the customs laws, regulations, or procedures to build up a good risk profile and ensure that their shipments can be cleared under more favorable lines. We now move to discuss the sanitary and phytosanitary, or SPS measures. As a reminder, SPS are measures applied by governments to protect human, animal, or plant life or health from risks arising from the introduction, establishment, and spread of pests and diseases and from risks arising from additives, toxins and contaminants in food and feed. The first group refers to rules that aim to ensure the proportionality of SPS measures. This means that while SPS measures are important to ensure human, animal, or plant life or health from risks, they should be relevant to the intended goal and not go beyond what is necessary to achieve an objective. They should also not put unnecessary burdens on traders. To meet this goal, SPS measures should incorporate rules on adaptation to regional conditions, equivalent, and science and risk analysis. Regionalization refers to the adoption of SPS measures to specific regions. This allows countries, particularly those with a wide variety of climatic zones, to maintain trade if pests or diseases only appear in specific regions and do not affect the whole country. For example, a swine fever outbreak in a southern province will not affect the export of pork from a northern province. The equivalence rule provides the government authority the flexibility to adopt different measures so long as applied measures achieve the same level of protection as internationally recognized SPS measures. Equivalence needs to be granted by the importing country, following a process for requesting and granting recognition of equivalence for SPS measures. However, when equivalence is recognized, it will reduce costs related to test and certification procedures for exports. The rule on science and risk analysis requires that SPS measures are science-based, documented, appropriate to the risk circumstances, adopted in a transparent manner, and conform to relevant international standards, guidelines, and recommendations. This rule aims to ensure that SPS measures are adopted for legitimate purposes and suitable, and will not impose unnecessary burdens on traders. There are also SPS rules under the CPTPP that aim to ensure ease of compliance with SPS requirements. The first measure pertains to the import check. Import check means the inspection, examination, test or other procedures conducted at the border by an importing party to determine if a consignment complies with SPS requirements. The CPTPP requires that import checks done by the authority of an importing country must be based on risk and carried out without undue delay. Furthermore, the importing party is also required to provide information on testing procedures and notification on finding of nonconformity from import checks to allow resolution of the issue as soon as possible. In other words, When an exported good is rejected on the ground of nonconformity with the importing country's SPS requirements, businesses and cooperatives may request, with support from the national SPS authority, to request information and review the decision. While certification is a common method of providing assurances of SPS compliance, the CPTPP provides that the assurance may be provided through means other than certificates. When a certificate is required, the CPTPP ensures that the importing party limits the information it requires on the certificates to essential information related to the SPS objectives only. The CPTPP also encourages parties to develop model certificates, which will provide a uniform certificate and allow for ease of use and acceptance. The third group covers rules to facilitate the. It should be noted that while the CPTPP and other FTAs aim to lessen the burden for traders to comply with SPS requirements in the importing countries, traders still need to comply with SPS measures. Detailed provisions on SPS requirements applicable to traded products are provided under domestic regulations in both the exporting and importing countries. One product may be subject to several SPS requirements, such as residue level of contamination, restricted or prohibited substances, labeling and packaging requirements, and so on. Information on applicable SPS measures on a specific product by a specific market can be obtained from different sources, including the ITC Market Access Portal, the Vietnam Trade Information Portal, and the Vietnam National Trade Repository. We will be demonstrating how to use these tools in Module 3 of our training course. Stay tuned. In the next slides, we will discuss the technical barriers to trade, or TBT measures. As a reminder, TBT refers to measures that countries use to regulate markets, protect human, animal, or plant life or health, and protect the environment. TBT comprises technical regulations, which are mandatory, standards, which are voluntary, and conformity assessment procedures, which are procedures to determine the fulfillment of requirements in technical regulations or standards. While the CPTPP has several rules committing governments to eliminate unnecessary technical barriers to trade and promote good regulatory practice in the adoption of TBT measures, here we focus on some key rules with implications for cooperatives. The first rule is on mutual recognition. Mutual Recognition Agreement, or A, refers to a binding government-to-government agreement, under which the accreditation systems or results of conformity assessment conducted for one or more sectors in one country shall be recognized, or accepted as equivalent, in other countries. This will help traders save time, costs, and effort as they don't have to request TBT conformity in both importing and exporting countries. The CPTPP, therefore, encourages member countries to use mutual recognition agreements to accredit, approve, license or otherwise recognize conformity assessment bodies located outside its territory. As an SPS, transparency is also a key pillar. The transparency rule of the CPTPP requires information sharing between parties, including information on new and proposed technical regulations and conformity assessment procedures to allow for comments and engagement between parties. Similar to the case of SPS measures, if businesses and cooperatives hear about any new TBT measures that could be applied in their export markets, they could use this rule, with support from relevant government agencies, to request information and provide feedback on the implication of the implementation of such measures to their export operations. Further to information sharing, the CPTPP also encouraged parties to allow a reasonable interval of more than 6 months between the publication of TBT measures and their entry into force to allow exporters reasonable time to demonstrate compliance. Last but not least, the CPTPP encourages parties to facilitate the acceptance of conformity assessment results through mutual recognition of standard-setting bodies, exchange information on regulatory practices, provide technical advice and assistance, and so on. In many cases, cooperatives are the beneficiaries of these technical assistance on implementing TBT measures. The TBT chapter also contains 7 sector-specific annexes, which contain more extensive and specialized obligations than those within the chapter. For cooperatives, there are 2 annexes of potential interest as they link to the products currently produced by many cooperatives. These are the annexes on wine and distilled spirits, organic products. The Annex on Wine and Distilled Spirits provides guidance on labeling, including specific minimum requirements for labels. These include the product name, country of origin, net contents, and alcohol content to be clearly displayed within a single field of vision on the bottle. By spelling out all product information, this rule helps streamline the labeling requirements for wine and spirits, thus helping exporters comply with the TBT requirements on labeling. The annex on organic products is relevant to cooperatives, as many cooperatives have been producing and exporting organic products as a high-value added goods. This TPP Organic Products Annex covers two key commitments that aim to support trade in organic products. First, it aims to facilitating information exchange between countries on organic production, certification, cooperation, and related control systems. It also encourages equivalence or recognition of technical regulations, standards, or conformity assessment procedures related to the production, processing, or labeling of organic products. Similar to the SPS chapter, it should be noted that while the CPTPP and other FTAs aim to lessen the burden for traders to comply with TBT requirements in the importing countries, traders still need to comply with TBT measures. Detailed provisions on TBT requirements applicable to traded products are provided under domestic regulations in both the exporting and importing countries. One product may be subject to several TBT requirements, such as packaging, labeling, and marking requirements. Information on applicable TBT measures on a specific product by a specific market can be obtained from different sources, including the ITC Market Access Portal, the Vietnam Trade Information Portal, and the Vietnam National Trade Repository. We will be demonstrating how to use these tools in Module 3 of our training course. Stay tuned. The last content we will cover under this session is Rules on Intellectual Property Rights, or IPR, under the CPTPP that could be of interest for cooperatives. While the CPTPP provides rules for the protection of many intellectual properties, we suggest cooperatives focus on the three key assets: trademarks, geographical indications, and plant variety. It should be noted that the CPTPP only provide for the overarching rules, while these rules will be substantiated under Vietnamese law and regulations. The first IP of interest is trademark. In addition to the traditional trademarks, which mainly comprise letters and figures, the CPTPP requires parties to accept the registration of sound marks and encourages parties to register scent marks. Cooperatives, therefore, have choices of marks to make themselves distinctive in the markets. Furthermore, collective marks, for example, Thanh Nguyen Tea trademark, and certification marks, such as OCOP, can be used by several cooperatives for one registered trademark. The next IP is geographical indications. Similar to trademarks, geographical indications need to be registered to ensure protection. In Vietnam, several geographical indications have been registered, such as Phu Quoc fish sauce, Moc Chao Shan Tuet tea, Binh Thuan dragon fruit, Luc Non lychee, etc. All registered geographical indications in Vietnam can be found on the website of the Vietnam Intellectual Property Office. The term of protection for a registered trademark or geographical indication is indefinite. The third type is plant variety. Similar to the aforementioned types of IP, plant variety also requires registration for extending protection. However, unlike trademarks and geographical indications, the right to a plant variety has limited terms of protection to ensure that the right owner can make up for the investment made in developing the new plant variety, while also allowing the plant variety to bring benefits to the wider community after the end of the protection period. Currently, Vietnam provides the term of protection for a registered plant variety in 25 years for woody plants and 20 years for other plants. In addition to the three IPs that we just mentioned, there are also trade secrets, such as the recipe for a beverage product, industrial design, such as a new design for packaging, copyright and related rights, for example, a book about the history of a cooperative, patent, for example, a novel method for processing coffee. IP rights holders have the option to self-enforce their rights, for example, by applying technological measures to prevent any unauthorized copy of a song or a book, or by requesting the authorities to handle IPR infringements. The CPTPP provides the opportunities to oppose the registration or seek cancellation of the IPs. Furthermore, the CPTPP IP chapter also provides for civil, criminal, and border enforcement measures to reduce trade in counterfeit trademark and pirated copyright goods. Civil procedures and remedies include injunctions and provisional measures to prevent infringements, and to seek damages to compensate rights owners for injury. Border measures allow rights holders to request customs authorities to suspend the release of suspect counterfeit or confusingly similar trademark-protected goods or pirated copyright goods that have been imported. Customs authorities also have the power to act ex officio, that is, to act on their own initiative, to stop the release of suspected counterfeit trademark-protected goods or pirated copyright goods that have been imported or are destined for export. Finally, criminal procedures and penalties are provided for willful trademark counterfeiting, copyright or related rights piracy on a commercial scale, and for willful importation and domestic use of labels or packaging mark has been applied without authorization. Penalties include imprisonment, monetary fines, seizure, forfeiture, and destruction of the infringing goods. To effectively use their IPR, cooperatives should note that registration is required for most industrial property rights, which include trademarks, patents, industrial designs, and geographical indications. Registration is optional, but recommended for copyright and related rights to ensure the protection of rights holders. Once rights are established, rights holders can seek remedies against infringement under either of the three channels: civil procedures, border measures, and criminal procedures, as discussed earlier. Thank you for joining the course, and we look forward to seeing you in the next session.